Hey there, curious minds, and welcome back to the deep dive.
Great to be here.
Today, we're plunging into a really fascinating South African legal case. It tackles, well, a deeply human question, doesn't it?
It really does. It's about the truth of our origins, specifically paternity.
And it sets up this clash, this tension between a father wanting, scientific proof and the mother's certainty, plus all the established legal ideas.
Exactly. It's a compelling scenario. We're looking at personal belief versus scientific evidence versus fundamental rights, a complex mix.
Right. So our mission today is to unpack the case of YM, now MVLB. It's a 2010 decision from the Supreme Court of Appeal of South Africa.
And it really makes you think about what truth even means in a courtroom.
It does. We'll walk you through the story, the arguments, and the court's reasoning, which had some pretty big implications. So yeah, get ready to question what you think legal proof is all about.
Let's dive in.
Okay, let's unpack this. So the story kicks off early 2006. We have YM, let's call her M, and LB, we'll call him B. They start a relationship.
Yep, things move fairly quickly. By October, they're living together, November, engaged. Seems pretty standard at first glance.
But then things get, wow, complicated.
They do. B tells M he's going to be working away, maybe even abroad. So M moves back to her parents' place in Musina in March 2007.
Okay.
But here's the thing. B never actually goes abroad. And he starts calling M frequently, often it seems, well, under the influence. This puts a real strain on things.
Okay. And then comes the big news.
Yes. Late March 2007, M finds out she's pregnant. And she is absolutely certain B is the father.
No question in her mind.
None. And interestingly, apart from one very specific incident, an alcohol-fueled phone call where B denied paternity.
Right, I remember reading that.
Which he then took back the very next morning, apparently not even remembering saying it.
Yeah.
Paternity wasn't really a big issue between them initially.
But B's actions seem important here, too.
Hugely important. This is what the Supreme Court really picked up on later. Despite a letter from his lawyer after the birth denying paternity, B's actions before that told a different story.
Like what?
Well, he deposited R1000 into M's bank account. April, May, July 2007. Seems pretty consistent with supporting an unborn child, right?
You'd think so, yeah?
And even more significantly, in his own founding affidavit, the sworn statement starting the court case we're talking about, B explicitly stated he believed he was the child's father. He actually said he wanted to build a relationship with her.
Wow, so he put that in writing himself in the court documents.
Exactly. That's not just a small detail. It's a direct statement from him that became critical.
Okay, so despite M's certainty and B's financial support and stated belief, M decides to end the engagement.
That's right. In April 2007, when B visited Musina, she broke it off. They agreed to stay in touch, but M moved on quite fast.
How fast?
She got engaged to a former boyfriend, Mr. M, in June, and then married him in July. Same year, 2007.
Okay, things are moving quickly there, too.
This whole sequence definitely sets the stage for the legal fight. So September 2007, M tells B the baby's due date.
And the baby Y is born November 8th.
Correct. M contacts B after the birth. He says he wants to see Y. M says she'll sort something out later. Seems okay for a moment.
But only for a moment.
Right. Just 2 days after Y's birth, things escalate. B's lawyer sends a letter. It says B strongly denies paternity.
Which completely contradicts his earlier actions and his affidavit.
Exactly. But the letter also says he's willing to pay for blood and DNA tests. It's confusing.
Very. So how does M react to this sudden denial?
Well, M, who seemed open before, now responds via her lawyer saying B gets no parental rights or obligations. Zero.
Okay, drawing a line.
Which prompts another U-turn from B. His lawyer writes back just days later, now claiming B is 100% certain he is the father.
Wait, so now he's certain after denying it?
Yes. I.e. still insists on blood tests.
Right, so he's saying, I know I'm the father, but prove it to me scientifically.
Essentially, yes. M refuses the tests, and that's what leads B to go to the High Court, asking for an order to force M and the baby, Y, to undergo DNA testing.
Okay, quite a tangled web of statements and actions. So, faced with this, how did the Supreme Court of Appeal figure out what the actual dispute was? Did they see paternity as genuinely contested?
That's a key question. The SCA used a legal principle called Plaskon-Evans. basically, in these kinds of cases, decided mostly on papers, on affidavits.
Right, not with witnesses in court.
Exactly. The court generally accepts what the applicant B, in this case, says, unless it's just clearly nonsense or completely denied with evidence by the respondent.
Okay.
Applying it here, the SCA looked at everything B himself had said and done the money. The affidavit statement where he said he believed he was the father.
The crucial part.
Right. And they concluded that actually paternity wasn't really in dispute based on the evidence presented. B never actually denied it in his own sworn statements for this case. He just wanted scientific certainty.
And what about the High Court's idea that M might have been intimate with her new husband around conception time?
The SCA dismissed that. They call that finding unwarranted. Why? Because B's claim about that was just hearsay, something a friend supposedly told him. It wasn't direct evidence. And B himself didn't firmly state it as a fact, questioning paternity in his papers.
So the core issue for the SCA wasn't if he was the father based on probabilities, but B's demand for scientific proof.
Precisely. That distinction became absolutely central.
Okay. But before the SCA got there, the High Court did order the DNA tests. Judge Murphy felt quite strongly about it. What was his reasoning?
Yeah, the High Court decision by Murphy J. took a very different approach. His view was quite clear. Truth is a primary value in the administration of justice and should be pursued.
A powerful statement.
It is. He felt that excluding reliable science, like DNA tests, just because it involved a, quote, relatively minor infringement of privacy, would actually harm the justice system's legitimacy.
So the need for truth, especially scientific truth, outweighed privacy concerns for him.
That was the core of it. He also argued it was generally in a child's best interest to resolve any paternity doubts definitively using the best evidence available, get rid of the uncertainty.
So scientific certainty equals the child's best interest in that view.
That was the High Court's perspective, yes.
Yeah.
The pursuit of that scientific truth was seen as paramount.
Okay, that sets up a clear conflict. The High Court championing scientific truth above almost all else. But then the Supreme Court of Appeal steps in and completely overturns it. What was their counter-argument? How did Louis J. see it so differently?
This is really the heart of the judgment. The SCA, led by Justice Lewis, fundamentally disagreed with the High Court's broad generalization. They broke it down.
Okay.
First off, the standard of proof. The SCA stressed that paternity, like most things in civil cases, is decided on a balance of probabilities.
Meaning more likely than not.
Exactly. Is it more likely than not that B is the father, based on all the evidence? The SCA felt that standard was met here. B wasn't just asking to meet that standard. He was demanding scientific proof, absolute certainty. And the court said, well, you're not automatically entitled to that higher level of proof when the legal standard is already satisfied.
So the law doesn't require scientific certainty in every case.
Correct. The court's job is to apply the legal standard. Second point, the best interests of the child and the court's power.
Right. The High Court leaned heavily on that.
Yes. And the SCA acknowledged, look, courts are the upper guardians of children. They do have an inherent power to order tests if it's genuinely needed for the child's welfare. Section 37 of the Children's Act even allows for it. But, the SCA said, that power wasn't warranted here. Why? Because, as we discussed, paternity wasn't actually in dispute on B's own evidence. Ordering a test wasn't necessary to resolve a genuine legal doubt in this specific case. It was more about B's personal need for confirmation.
Yeah, right. Context matters.
Hugely. Which leads to the third and maybe most critical point. The balancing act between truth and rights.
Privacy, bodily integrity.
Exactly. The SCA explicitly said you can't make a general rule that discovering the truth always overrides constitutional rights like privacy and bodily integrity. It's just not that simple.
So it's a case-by-case assessment.
Absolutely. These rights are fundamental. They can only be limited if it's reasonable and justifiable under Section 36 of the Constitution that involves a serious balancing test. And here, forcing M and a baby to undergo DNA testing when paternity wasn't legally in doubt was not seen as justifiable.
That's a strong stance on protecting those rights.
It is. And they even quoted an older case, SAFLII v. Pravitha, with that poignant line from Judge Didcot. It is not necessarily always in an individual's interest to know the truth.
That really makes you pause and think. We often assume knowing is always better.
We do. But the law, and perhaps life, is more nuanced. And finally, the SCA clarified the court's role. Its job is to settle disputes based on legal standards, balance of probabilities in civil cases. It's not there to conduct scientific investigations just to satisfy one party's desire for absolute proof, especially when constitutional rights are involved.
So determine the legal issue, don't necessarily chase every scientific rabbit hole.
Pretty much. Each request for a test needs careful, individual consideration, focusing squarely on that child's specific situation and best interests, not a blanket rule.
Right. So the final outcome. SCA says no forced DNA tests. The High Court order is overturned. What's the big takeaway here? What's the lasting significance of this deep dive into YMVLB for people studying law or anyone just interested in how justice works?
Well, it's hugely significant. It sets a very clear boundary in South African law about when courts can, and perhaps more importantly, cannot order scientific paternity tests.
It limits that power.
It does. It clarifies the court's inherent power, even guided by the child's best interests, isn't unlimited. It's not there just to rubber stamp what's already proven on balance, or to fulfill a parent's quest for scientific confirmation over legal resolution.
So it really puts the court back in the role of balancing rights, not just being a truth-finding machine at any cost.
Precisely. It highlights that delicate balance, that tension between our understandable desire for truth, especially scientifically proven truth, and the absolute need to protect fundamental constitutional rights: dignity, privacy, bodily integrity.
Rights that belong to both the mother and the child.
Absolutely. It reinforces that the court resolves disputes using legal standards, like balance of probabilities. It's not always about achieving scientific certainty if the legal question is already answered, and forcing the issue would unjustifiably infringe rights.
For law students, then, it's a real lesson in constitutional limits.
Definitely. A powerful illustration of how constitutional rights can put the brakes on even something that sounds noble, like finding the truth. And it shows the best interests of the child. Principle isn't just a magic phrase you can use to justify anything. It requires specific, careful application to the facts of the individual case.
Okay. And that brings us to the end of this deep dive into why now MVLB. We've journeyed through a complex personal story that became a major legal test case.
We saw how that desire for scientific proof clashed head-on with legal standards of proof and fundamental rights.
And how the Supreme Court of Appeal navigated that, emphasizing rights and the specific context over a generalized pursuit of truth.
It's a really stark reminder that justice, in the legal sense, isn't always synonymous with absolute scientific certainty. It's often about finding a just outcome based on the evidence presented, respecting legal procedures, and upholding those core constitutional rights.
Which leaves us, and you, with something to think about. What does it really mean for a truth to be legally established, especially when that legal truth doesn't satisfy someone's demand for scientific proof?
And perhaps, when does that personal need for certainty cross a line? When does it become an unfair imposition on someone else's rights, particularly when a child's privacy and well-being are right at the center?
Lots to chew on there. Thank you for joining us on the deep dive. We hope this exploration gave you a clearer picture of the intricate balancing acts within our legal system.
Until next time, keep exploring.
Keep questioning and keep learning.